So, hige scroll manada. Sorry.
Sorry, sir.
Em tondrangamma. Correct. Right put on. Thank you. Okay, Professor. Sir. Thank you. Very kind of you. Thank you, Professor Sadasiv sir, for your brief introduction about myself. Hello, all the professors across the country. Hello.
Hello, sir.
Hello, sir.
Good afternoon, sir.
Good afternoon, sir.
Good afternoon, sir.
Yeah. Very good afternoon to each and everybody and all the participants. You owe a lot of responsibility as a professor. I am basically from a law background. Nevertheless, law cannot be understood in a better way without the support of the history, as we have already discussed in the previous session. There was always a question arises, how can you relate law to the history? And of course, no subject can sustain without the support of the history. In fact, and we also make a reference to the various historical factors for the better understanding of the term law. Because without making reference to the history, historical evolution, historical development, we are unable to understand what actually going on in and around us. I will discuss all these factors without any other doubts as the case may be, but we will have a discussion in the last 15 minutes. Okay. There is also one important question, whether law can sustain on its own without the support of the various social science, various pure science, various applied science or not. Because a fundamental question comes before us is that when we were studying law, the entirety of the law subject was entirely different. Now, the Bar Council of India has introduced 5 years law course, which comprises of a BCom LLB, BA LLB, BBA LLB, and BSc LLB has also been introduced. So, when a candidate or when a student is pursuing the 5 years course, he is definitely expected to study the law of the world, law of the country, including what has been stated in a legal document like Constitution of India. So with this background, let me make my presentations before this August Assembly. I know that as far as the definition of a law is concerned, we can witness many definitions. Many definitions can be had from a different angle. For example, from the capitalistic point of view, the definition of a law is different. From the socialistic point of view, the definition of law is different. Okay, from the dictatorial government point of view, the definition of a law is different. Because what kind of a government and how the sovereign who enjoys the sovereignty, makes the law, treats the society, treats the people, is the sole criteria for the definition of a law. For example, In England, we can say that by making reference to the definition offered by one stalwart like a John F. Austin, that a law is a command of the sovereign backed by the sanction. Backed by the sanction. The same law is also available with us. Actually, this is very, very important. I will explain it. Now, for example, but we have our own example, which has been influenced by Gita, which has been influenced by Nareda, which has been influenced by Mitakshara law, which has been influenced by Yajnavalkya, and so on. Many such things are there. Many such things. Now, for example, we may believe it in India, Yata Raja Tata Praja. So, as the king, so the people. So, this is very, very important. As the king, so the people. So, if the king is wise, if the king is so kind, if the king is very generous, people respect him. People respect him. People obey the order passed by the king. If the king is a womanizer, if a king do not look into the total welfare of the people, then people will never respect him. That's what actually we mean to say that. So, from the different perspective, it is different definitions can be had. So, from the analytical point of view, no, look at the thing. Law is a command of the sovereign backed by sanction. Whereas Karl Marx, in his Das Kapital, has given the different definitions with respect to the state and the law. State and the law. This is very, very important, because if you want to discuss the history, there must be state, there must be population, there must be territory, there must be sovereign. These four important ingredients are there, and it should be there. That means there should be a state. There should be a state. Then what is actually the state means and includes? What is actually the state includes? Now, in a general way, state is an institution which fulfills the legitimate expectation of the people. Please make note of it. State is an institution which fulfills the legitimate expectation of the people. Go back to the Thomas Hobbes, Leviathan, in the 1560, please make note of it, a treatise, a literature created by Thomas Hobbes, who says that king should enjoy absolute sovereignty in his territory. King should enjoy absolute sovereignty in his territory, and he should be there. Before that, the situation in England was entirely different. Actually, the church were controlling the government, but the credit should go to Thomas Hobbes, who openly made his comment through his literature and treatises. Leviathan says that king must be given an absolute power to enjoy the sovereignty absolutely without any restrictions. That's what actually he says that. Now, it is said that law is a command of the sovereign backed by sanction. It is said that. Why it is so? That this statement has been made by John F. Austin in England, because he believed in the order passed by the military officer, highest military officer, to lowest military officer or to the lower military officer. Now, you mean to say that there is a military officer. When a military officer makes a command, the lower officer, whether they like it or not, they should obey it. And that is still law. That is still law. That's what actually it is said that. So it is said that law is a command of the sovereign backed by sanction. No, it is here, there is a command. There is no order where king used to, you take anything. Since the time immemorial, a sovereign is enjoying it. Order. You mean to say that if you make a reference to Roman Empire, if you just make a hands like this, that means it's a pin drop silent can be seen. People should respect it. People should respect it. So command means it's an order. Sovereign means is a king. Sovereignty means the absolute power. Backed by sanction means the existence of fear in the minds of the people. This is very, very important. Because if law is enacted, if it is not backed by the sanction, if there is no fear of punishment, nobody would follow it. That's what actually, since the time immemorial, we are actually enjoying it. So only when there is a fear of punishment, please listen to me. Only when there is a fear of punishment by the sovereign, then only people would respect. The law passed as a command by the sovereign. It can also say that the system of rules which a particular country or a community recognizes as regulating the actions of its members and which it may enforce by the imposition of penalties. This is what actually it says that. The term penalties that has been used in this particular para discusses the existence of the sanction. Because if law enacted without the sanction, without the fear of penalties, then nobody would respect the law. Nobody would respect it. Now, for example, it may be the imposition of wearing of helmets. Or, for example, if you are owning a car, wearing of a seat belt. Earlier, about 2 years back, that was not mandatory. Now, the traffic rules have been amended. It says that if you don't wear the helmet, then it is punishable, subject to penalties. So in order to avoid the penalties, you wear the helmet. Or if you wanted to, actually, those laws have been enacted only for the sake of the people, But we don't really obey it. So for example, by making it mandatory, wearing of the seat belt while you are driving a car or any other similar vehicle, then you could avoid the accident and the injury can be avoided. That means law usually enacted in order to protect the interest of the people in the society, that we are actually ignoring it. That's what actually we have learned from our history. That's why it is said that members are there. There is a limitation. The territorial limitation is there. Sovereignty is there. And the state is there. Now, from the capitalistic point of view, it says that. Now, you can just go back to the history now. It says that. Now, for example, in DoS capital, The Karl Marx comes out with a definition of a state. State is an organization which has been conceived to protect the haves at the cost of the have-nots. This is very, very important from the point of understanding the state. Please make note of it. State is an institution which has been conceived to protect the haves, at the cost of the have-nots. Haves are there, ullavaru, ullade iruvaru. Ivribru idare. Even today, the similar, I mean to say that the first and the second and the third definition is relatively applicable in almost all the countries as far as this definition is concerned. Now, I just wanted to make it very clear history. I don't want to go in the definition is concerned, the study of a past events, particularly in human affairs. I mean to say that history need to be studied, and even I, as a professor of a law, I need to study history. As Ambedkar has already made it very clear, one who forgets history cannot create history. I must know what is history. I must know what has actually happened in my society, in my community, in my state, in my nation, as the case may be. So now here, we need to study the past events. We need to study particularly the human affairs, how our forefathers, grandfathers, great-grandfathers were actually living, under what circumstances they could survive, under what circumstances they could live very contented life. I mean to say, ತೃಪ್ತಿದಾಯಕವಾದಂತ ಜೀವನವನ್ನ ಹೇಗೆ ನಡೆಸ್ತಾ ಇದ್ರು, ಯಾವ ರೀತಿ ನಡೆಸ್ತಾ ಇದ್ರು. Now we have got everything now, as the case may be. Nevertheless, there is no contentment. ತೃಪ್ತಿ ಅನ್ನೋದೇ ನಮ್ಮಲ್ಲಿಲ್ಲ. But when you make a comparison with the human affairs of our elderly people, they may be my father, there may be your father, or your grandfather, great-grandfather, great-great-grandfather, or a mother, as the case may be. And you will really astonished, you will really surprised to know that how they were actually enjoyed their life. That's what actually it says, that the history means the definition that has been offered to you in relation to the law, that study of a past events, that is very, very important, particularly in human affairs. We need to study the history because we need to evaluate the evolution and the development of a law. You mean to say that in any society for the matter. So if you just to make a reference to any society for the matter, as the case may be, for example, a great sociologist like M.N. Srinivas, he has come out with a new concept called the Sanskritization, as the case may be. Why that word Sanskritization was actually came into existence in a country like India, as the case may be. Why the poor people actually pretended to follow the customary principles of the particular higher caste people in our society, as the case may be. We need to evaluate the evolution. Hege samaja ವಿಕಸನ ಆಯಿತು, ಹೇಗೆ ಅಭಿವೃದ್ಧಿ ಹೊಂದಾಯಿತು ಯಾವುದೇ ಸೊಸೈಟಿನಲ್ಲಿ ಆದರೂ ಕೂಡ, how they were involved in the engineering, how they were actually involved in the social engineering, how they were actually involved in the architecture, how they were actually involved in the agriculture, how they were involved in the societal matter, how they were actually believed in the institution like a marriage. ಮದುವೆ ಅನ್ನುವಂಥ ಸಂಸ್ಥೆಯನ್ನ ಹೇಗೆ ಅವರು ರೆಸ್ಪೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ರು, ಹೇಗೆ ಅವರು ಪರಿಕಲ್ಪನೆ ಮಾಡ್ಕೋತಾ ಇದ್ರು, how they were actually conceived it, how they were actually leading a very happy life, very contentful life. That's what actually it is said. And that's why I just wanted to make it very clear that the praise human affairs. That was actually is very important point to be discussed from the point of a law. From the point of a law. Now, the question comes before us is that whether the law was existed anterior to the society or posterior to the society or not. A question comes before us. Please, this is something you may feel that it is something unknown, but I'm just going to convince you people. Now you mean to say that I made a reference to the definition offered by the John F. Austin in the first slide, that law is a command of the sovereign backed by sanction. So that was a definition given by the John F. Austin in his book called Jurisprudence Determined. Now here, John F. Austin says that is an English legal theorist who published the province of jurisprudence determined in the year 1832 were different. He was against to the natural law. He says that, John F. Austin says that in any society for the matter, history says that law can be witnessed, can be seen, which is posterior to the society. That means only when you have conceived the concept of society, then only law would come into existence, otherwise not. Samaja annuvanta parikalpane banda melene kanunugulu, it may be in any form, as the case may be. I am not the law, as I have already made it very clear, it may be common law, it may be codified law, as the case may be. Now, for example, it is said that what we are actually enjoying in the form of a custom since the time immemorial, it is also known as a law. Law can be seen and understood by the support of these things, That means law means, hello, law means and includes the custom, precedent, and the legislations. As far as the custom is concerned, custom is available since the time immemorial, historically speaking. Custom is available in any society for the matter since the time immemorial. No society can be existed without the support of the custom. It may be you are also actually sincerely acclaimed to the custom, even at your house. For example, when you are in case of a cremation, or in case of a celebration of any festivities, or in case of offering a prayer to the people, or in case of actually making a solemnization of a marriage, this is sufficient. For example, in case of a solemnization of a marriage, for example, in Christianity, or in Islam, or in Hinduism, there is a separate custom that you cannot so easily ignore. People are there. I'm not actually denying it. That's why it is said that, historically speaking, Special Marriage Act was enacted in the year 1954, which came into existence in the year 1955, as the case may be. Nevertheless, if you don't marry a girl or a boy under the Special Marriage Act, then you will have to be abide by the custom. You have your own custom. For example, in a country like India, everybody and every caste and every family enjoys their own customs, historically speaking, enjoys their own customs, as the case may be. There may be so many confusion with respect to that, but for solemnization of a marriage is like that. Or it may be with respect to performance of a Shraddha. So Shraddha, when it is to be done, how it is to be done? So like that. Or it may be offering up a prayer, or visiting of a church, visiting of a mosque, visiting of the what we call that temple, as the case may be. And all these things are imbibed and inculcated by us by virtue of historical factors. That has been offered by our elderly people. That means without custom, no society could be existed. Now the question comes before us is that, that's why it is said that custom, precedent and legislation. Custom is there. Precedent means it is called a decision given by the court. Decision given by the court. And the legislation means that I'm going to discuss it. The act passed by the so-called the legislature. It may be Vidhan Sabha or it may be Parliament, in accordance with their limitations as it is stated in the 7th schedule of the Indian Constitutions. 7th schedule of the Indian Constitution. Now, I will come back to that particular one important question. Frederick Karl von Savigny, it is called Savigny, a German philosopher and a father of historical jurisprudence. Views are very, very different. He says that law is, historically speaking, please make note of it, law is, historically speaking, is anterior to the society. This is very, very important. It's an anterior to the society. That means even before the concept of society was conceived, even before the concept of society was conceived by us, according to Frederick Karl von Savigny, he says that laws were there and they were subject to evolutions. Andre, let me make it in Kannada for the benefit of the participant in a better way. Samaja ಅನ್ನೋ ಪರಿಕಲ್ಪನೆ ಬರುವುದಕ್ಕೂ ಮುಂಚೆಯೇ ಕಾನೂನು ಇತ್ತು ಅಂತ ಹೇಳ್ತೇನೆ. Now this has been rebutted by John Fasti, who is the father of analytical jurisprudence. No, he says that in this province of jurisprudence determined, published in the year 1832, he says that concept of a law, historically speaking, came into existence only after the society has been conceived. These two views are very, very important. ಇವನೇನ್ ಹೇಳ್ತಾನೆ, ಜಾನ್ ಫಾಸ್ಟಿನ್ ಏನ್ ಹೇಳ್ತಾನೆ, ಸಮಾಜ ಅನ್ನುವಂಥ ಪರಿಕಲ್ಪನೆ ಬಂದ ಮೇಲನೆ ಕಾನೂನು ಇತಿಹಾಸವನ್ನ ನಾವು ನೋಡಬಹುದು. ಆದರೆ ಫೆಡ್ರಿಚ್ ಕಾರ್ಲ್ ವೋನ್ ಸ್ಯಾವಿಗ್ನಿ ಏನ್ ಹೇಳ್ತಾನೆ ಅಂತಂದ್ರೆ, ನೋ, ಇದಕ್ಕೆ ಸಮಾಜ ಅನ್ನೋಂಥ ಪರಿಕಲ್ಪನೆ ಬರೋದಕ್ಕೂ ಮುಂಚೆನೂ ಕೂಡ ಕಾನೂನು ಅನ್ನೋದು ಇತ್ತು, ಇತಿಹಾಸ ಅದನ್ನೇ ಹೇಳುತ್ತೆ. ಅದರಿಂದ ಪೀಪಲ್, he may be a single person, single family, they have their own laws in their respective society, and moreover natural law was there. So ಪ್ರಾಕೃತಿಕ ಕಾನೂನು ಕೂಡ ಇತ್ತು, ಅದನ್ನು ಕೂಡ ಕಾನೂನು ತಾನೆ ಅನ್ನುವಂಥ ವಾದವನ್ನ ಮಂಡಿಸಿದವನು ಫ್ರೆಡ್ರಿಕ್ ಕಾರ್ಲ್ ವೋನ್ ಸ್ಯಾವಿಗ್ನಿ, a German philosopher, and who is also known as a father of a historical jurisprudence. That's what actually. But this was criticized by an English legal theorist, John Fostin. He said that he was against to the natural law. Nothing like that. Law means it must be made by the sovereign, with whom the sovereignty lies. With whom sovereignty lies. ಜೊತೆಯಲ್ಲಿ ಸಾರ್ವಭೌಮ ಅಧಿಕಾರವಿರುತ್ತೆ. ಎಲ್ಲವನ್ನೂ ಕೂಡ ನಾವು ಇತಿಹಾಸವನ್ನ ನೋಡಿದಾಗ ಅವನೇ, you just look at the Roman history, you look at the Mesopotamian history. Just look at the Mesopotamian history. You just look at the Indus Valley civilizations, or you must also look at the Gita, or you must also look at the Nareda and various other important literature. Case maybe. Please silence. They say that it is very, very important to be noted down that law means it should be always read with the existence of the sovereign, with whom the sovereignty lies. Then natural law, it says that. The theory of natural law says that this is a part and parcel of the history. Humans possess intrinsic sense of a right and wrong that guides our reasoning and behavior. That means you mean to say that it's all your intrinsic sense. It's all depending upon your conscience. You mean to say that you believe in your conscience because your conscience says that. Your conscience says that. Please make note of it. Whether what you did is a right or a wrong. This is very, very important. What you did is a right or a wrong. ನಿಮ್ಮಲ್ಲಿ ನಿಮ್ಮ ಆತ್ಮ ಅಥವಾ ನಿಮ್ಮ ಒಂದು ಪ್ರಜ್ಞೆಯನ್ನ ಕೇಳಿಕೊಂಡಾಗ ಅದು ನಾನು ಮಾಡಿದ್ದು ಸರಿನೇ. Am I correct? Am I wrong? As the case may be. This is what actually it says that natural laws say that. The concept of natural laws are ancient, stemming from the times of a Plato and Aristotle, as the case may be. Because Socrates, Plato, Aristotle, all these philosophers, they believed in natural law. They believed in natural law. And they take the support of the natural law. And they always substantiate the natural law. And they say that without natural law, no government could sustain. That's why if the natural law is respected by the sovereign, if the natural law is respected by the sovereign, such natural law for the administration of a state will last longer. This is what actually it is said that. So natural law is a constant throughout the time and across the globe because it is based on human nature, not on culture or customs. That means you mean to say that constantly it is there, but it is subject to change. It is subject to change. You know, for example, I can make a reference to the 10 Commandments. I think that has been actually made available in almost all the media, and the literatures are available, and the movies have also actually says that as the case may be. So Moses, you may call him as a Messiah. You may call him as a Messiah who actually free the slaves from the clutches of the slavery, And then after the slavery comes to an end, this is very, very important. History says that, please make note of it. After the slavery comes to an end and everybody becomes free man. But all of them have become an unruly person. This is very, very important. I think if you see that movie called 10 Commandments, you can see that. It is available in the Hebrew language also, as the case may be. Or once it says that you become a free, everybody become an unruly horse. So in order to contain, in order to restrict the unruly behavior of that particular behavior of an individual, the God has given, it's a belief. I'm not actually propagating it. Please make note of it. I'm not propagating it. It's a belief. In order to restrict an unruly behavior of an individual, the 10 Commandments was actually offered by the God through the Moses. That's what actually it is said that. So go back to the 4,000 years back, as the case may be. All these things were there. Man, because basically man enjoys the hierarchical system. Basically, man enjoys the hierarchical system. That you can actually say that now, even today, majority of the people are proud about their caste, as the case may be. So that's what actually it is said that, though it is incorrect. Now, history of a law. History must be studied how law has evolved, why it has changed. Legal history is closely connected to the development of civilization and operates in the wider context of the social change. Society is not like a, please make notable, a society is not like a stagnant water. Society is like a running water. If the water is running water, it is clean and you can convert it as a potable water. You can convert it as a potable water. That is drinking water. That means what we have seen in the history, you may call it as a legal history. No law except the natural law is said to be permanent law. No law made by the human is said to be the permanent law. And we have seen it, as the case may be. That's why it is necessary that history must be studied, how law has been evolved, how law has been conceived, how law has been accepted, how law has been respected, how law has been imposed, how law has been questioned, how law has been challenged. Please look at it. Just because a person is just silent, it does not mean that he has fully accepted the entirety of the law. No, it is not like that. That's what actually we have seen from the history. There is a change. It ought to be changed. Change must be seen and can be seen, and it varies from one generation to another generations, as the case may be. Now, I mean to say that I may belong to different generations, but the present generation demand is different. Present generation demand is different, and the next generation demand is different. Why it is so? The government is expected to reach their expectation. That's why it is said that the Constitution of India has been amended for more than 100 times, because the state, through the Constitution, through the legal document, they have to address the problem being faced by the people, as the case may be. Now, you mean to say that there is a bill called Reproductive Rights of a Woman. Reproductive rights of a woman. The reproductive rights of a woman is being discussed in the parliament for the past 60 years also. A consistency in struggling, a consistency in demanding for the right by the woman with respect to that reproductive rights, which could be enjoyed solely by the woman, now is taking place. That's what actually history says. You mean to say that some people argues that the reproductive rights that has been conceived, a bill that is pending before the parliament, which may be enacted in the days to come, is against the male dominance in the society, like Hindus or Christianity or Muslim, as the case may be. Nevertheless, the rights of a woman ought to be protected. That's why it is said that history ought to be studied. History ought to be studied, how law has evolved, why it changed, what are the reasons, why we cannot actually keep that law as a permanent law. Does it require any amendment? Does the law that is existed now will not respond to the needs of the present generation? That's what actually legal history says about it. And in fact, it's in the development of the civilizations. I mean to say that my children, their approaches, their attitudes is entirely different. It is entirely different. And I may feel that it's very strange. It's very strange. I may not cope up with their demand. as the case may be. I cannot cope up with their demand. And they always claim that I'm old enough to not to accept them. Hey, yarapado. I may not accept it. My children may not accept it. And this is nothing but evolution. This is nothing but development of the civilization. And that's what actually history and the legal history speaks about. That's why history must be studied. Otherwise, if you don't study the history, you cannot understand any other subject as the case may be. Any other subject as the case. So that's why it is said that in a wider context, now there is a social change, as I have already made it very clear. Every minute, every second, the society is subject to change. With and without our knowledge. With and without our knowledge. Whether you accept the change or not, it doesn't matter. Whether you accept the change or not, it doesn't matter. But society is subject to tremendous social change. And it is happening. It may be your attitude, it may be your culture, it may be your food culture, as the case may be. Then, as the case may be, it is subject to tremendous changes. And for that, many things are actually supplementing. Now you may call it as a globalization. Now, for example, as the case may be, the concept of a globalization, concept of a privatization, concept of a liberalization is not at all a new concept. It's not at all a new concept, even in a country like India. Huyen Song and Pahiana, who have visited India, they have actually recorded it. They say that open market system was actually available. Anybody can actually see that. So, Jawaharlal Nehru, in his literature, he has made it very clear that Kabuliwala, there was a book written by him. Then he says that how a man, Kabuliwala, usually comes from Afghanistan. It may be about 100 years old story, as the case may be, via Afghanistan to sell the dates. And Jawaharlal Nehru was also actually very eagerly waiting for such things, as the case may be, the arrival of the Kabuliwala, as the case may be. It is
Kabuliwala written by Rabindranath Tagore.
Is it so? Yeah, it may be, yes. But it's similar to the Nehru, I think. Right? Now, look at the thing, 7 types of law in general. I mean to say the Constitution. It too has its own history. I mean to say that I don't think that, now for example, the US Constitution has the history of more than 200 years. But ours has a history of more than 70 years, as the case may be. It's in a supreme body that laws and governs the government. And the statutory law, I mean to say that written of codified law, such as legislative acts, declaration or declaring, commanding, and prohibiting something, where a person should not do anything. This is what actually it say that preventing a person from doing something is also a law. Declaring a person what he is also a law. So common law, that means the decision given by the court like a precedent, and the customs, as I've already made it very clear, which is also known as a case law. It may be a civil law, a private law. It is available because everybody enjoys their private law. Everybody enjoys the right to privacy. Everybody enjoys. That's what actually I'm telling that. And if you say that, if you make a reference to the Puttaswamy versus State of Karnataka with respect to the informations we actually given to the state government for getting the Aadhaar card was also questioned with respect to the violation of the privacy, and it is still there, and you can just made it very clear. A criminal law, It is known as actually public law and equity law, administrative law, tax law. Then that means many and innumerable number of laws can be seen. They have their own. Now, for example, we have Vishnu.
Hello.
Hello. We have Vishnu Sharma. We have
Hello.
The purpose of enacting the law, knowing the history, means to say that a person who understands the historical context of development of legal system through history have a real advantage to frame the law for the future. To frame the law for the future, as the case may be. Now that means if you want to have a good law, if you want to have a very sustainable law, by referring to the constitutions, then you need to refer the historical events. You need to refer the history of various laws enacted in the earlier period. It gives an experience in logical organizations. That means to say what they have not addressed, where they have erred, where they have committed mistakes. So by reading the previous laws through the history, you can overcome that particular errors by enacting it. Now, for example, earlier, many enactments have been passed. So the present legislature will actually question itself. Why this law, which was already existed, was not subject to sustainability. Why it could not sustain for a longer period? Is there any problem with that? Then you actually look at the historical context. You look at the historical context as the case may be. Then it will also help in conducting the research as the case may be. Research will provide as the case may be. Now, for example, law commission is there. Before recommending the central government to pass a legislation with respect to that, the law commission will conduct the research. They will also gather the feedback from the people through the questionnaire or via questionnaire, and they say that they will try to understand what is the feelings of the people for the best law that could be enacted. So for all these things, you need to look at the historical context, history of the law that has been already enacted or not, as the case may be. Now, for example, it is said that, no, only for the purpose of discussion, as the case may be. Now, earlier, now what actually it says that there was a sedition law. So what we mean to say that we never ever studied it. Now, all of a sudden, the sedition law, which was enacted about 100 years back, you mean to say that now it is being revived, and because sovereign has its authority to control the people who goes against the integrity and the sovereignty of the nations, as the case may be. Now, during the previous governments also, we never ever actually thought of it. Even during the emergency also, the sedition law was not actually enforced so strictly. Now it is that now many articles are being actually published in almost all the international journal and in the national journal, as the case may be. Then that means you mean to say that in order to combat the present situation, is there any such historical events that was actually available? And in that regard, you need to study the history. This is also known as actually legal history. What the laws and the decision given by the court, like highest appellate court from Indian overseas, that is what actually overs, that means Privy Council before the independence, we usually refer. are now since 1950, when India adopted our constitutions, what the judgment has been actually given. For example, it may be A.K. Gopalan versus state of Madras, or for example, Sajjan Singh versus state of Punjab, or for example, Keshavanandi Bharati versus state of Kerala, or for example, Maneka Gandhi versus Union of India, and various such things are there that will actually discuss the historical evolution of a law. Why it is so? Why it is so? As the case may be. So, by looking at the history of law and the law which is blend of history, you will learn a lot of things. As the case may be. Law may be changed due to the changes in the expectation of the people at large and the changes in the individual rights as well as to protect the people from harm. That means, I mean to say that my expectation was entirely different. I mean to say that. Some elderly professors are also attending this course. Even today, when earlier it was only roti, kapda, aur makan. That was only the manifestos of every political parties. Roti, kapda, aur makan. Food, cloth, shelter. Now we mean to say that. Or for example, very recently, about 20 years back or 23 years back, so every political party used to say that, no, if we come to power, we will create 2 lakhs of employment opportunities to people. As the case may be now, the unemployment problem is no more remained as an important manifestos of any political party for the matter. Because expectation of the people is entirely different. It is depending upon the generations. My expectation was different. When I was young, my expectation was different. I need to feed for myself. But the present generation expectation is not like that. That means the expectations of the people in every generation is subject to tremendous changes at large. And whereas the individual rights also get fabricated. Individual rights also get moduled, subject to mutant. That means the rights of an individual, consumed by an individual, is taking and subject to new interpretations, with new expectations, as the case may be. Earlier it was not like that. But now the interpretations is entirely different because it is subject to the things. For example, as the case may be, when the Bengal famine was there, the what we call that British government did not do anything. Or for example, in the year 1918, when the Spanish flu was actually erupted, it also came to India because of the herd immunity, and the British government did nothing because the research activities during that period was very, very nil, and there was no government support also. Now it is changed. The duties of the government is subject to tremendous changes. It is subject to tremendous changes. Some codifications, you mean to say that, as I have already made it very clear, codification is entirely different from that of the consolidations. Consolidation means putting together everything. But codification means putting all the customs and the legislations in a very logical and in a systematic way in order to overcome any confusion that existed in those legislations, as the case may be. So now here, there may be Rome 12 table, which was existed in the 451 and 450 BC. Code of Manu, 2nd century BC and the 3rd century BC. Hebrew Code, which was known as available in the 6th century BC. Code of Hammurabi, actually, which was existed in the year 1755 to 1750 BC. There was also called Attic Code of Solomon, where the date was not so exactly available. That's why I just skipped. But that means to say that some codification was there. If you just make it a reference to the Vedic period, as the case may be, it states that. Or for example, it may be Yajnavalkya or Mitakshara, Dhayabhaga, as the case may be. Then you can say that what actually the personal property and the private property means and includes, and all those things are there. So you may not make a reference to all these codification, no. But in a country like India, Mitakshara and Dhayabhaga is still available for Hindus. It is still available and it's their personal law. So Mitakshara is available in the entire country except in West Bengal, and Dhayabhaga is available in West Bengal. And the property is being distributed in accordance with that, subject to the decision that can be given by the Honorable Supreme Court, where it could mend it and it could change it and it could supplement it, as the case may be. All such things are there. That means, so look at the things. The Code of Manu, though we criticize it, some people criticize it, but it's still available and still it will have an impact. It will have an impact. Whether you actually support it or not, whether you oppose it or not, it is available in one way or the other way. Rome 12 table was also available even today. And Hammurabi Code, they have their own impact in that. All these things are there. I'm not telling that they are absolutely irrelevant in the present day context, irrespective of the many legislations have been passed in order to overcome all these things. I don't think that. But one way or the other way, their impact is always there. Their impact is always there. So under that circumstances, in the present 21st century, our way of thinking is entirely different, as the case may be. But nevertheless, you can go for it. You can take the support of it, as the case may be. That's why you mean to say that Ambedkar made it very clear while discussing the Article 26, 27, 28, 29, 30 of the Indian Constitution. The term religion has not been explained. Please make note of it. The term religion has not been explained in any part of the Constitution, because it is basically a matter of your faith. It is basically a matter of your conscience. I may offer a prayer to a nature. You may offer a prayer to a deity, or you may offer a prayer to the sun. You may offer a prayer to your mother or your parents, as the case may be. That is left to you. It has not been actually said that. That's why you can just make it very clear. And if you make a reference to the debates that was taken place in the Constituent Assembly, it has been made very clear. And the argument put forth by Dr. B.R. Ambedkar was overwhelmingly accepted by almost all the members who were attending the Constituent Assembly. And nothing has been spared out. It is said that, yes, when Ambedkar wanted to bring the Hindu Code Bill, as the case may be, yes, nobody could actually support it. And the then Nehru government did not actually table before the parliament. And against to that, Ambedkar tendered resignations, as the case may be. And now, what was conceived in the Hindu Code Bill in the early 1950s, now it is being extended to the empowerment of all the women in the entire India, as the case may be. What I just wanted to tell you, attempt was made earlier, about 70 years back. Attempt was made. Nevertheless, then it was actually not, many people says that it is not necessary. The conferring the co-personary right to women is not what was not necessary. Now, by piecemeals, everything what has been conceived in the Hindu Code Bill is being implemented by the Parliament itself. As the case may be, among them, it is also one important point. Take, for example, Hindu Marriage and Divorce Act 1955. And before the passing of the Hindu Marriage and Divorce Act of 1955, women never ever enjoyed giving divorce to her husband. Nothing like that. And monogamy was actually introduced. Women were not actually given a right to give her divorce against her husband. So polygamous marriage was actually allowed. That's what actually it is say that. Now it is very clear. Codification is there. All such things are there. We are actually enjoying it. We are enjoying it. Nevertheless, it may not have a direct impact on the making of a legislation in the present day context. No, but it will have its own impact in the present day context. So you can take it either positively or negatively. ನೀವು ಅದನ್ನ ಸಕಾರಾತ್ಮಕವಾದರೂ ತಗೋಬಹುದು, ನಕಾರಾತ್ಮಕವಾದರೂ ತಗೋಬಹುದು, as the case may be. So it is because of that we were actually here to discuss. So it is said that what we have learned from the history, actually, now for example, you may go back to the June 15th, 1215, it is called Magna Carta, the first ever
Bill of Rights.
late charter is a document guaranteeing English political liberties that was drafted by Runnymede, a meadow by the river Thames, and signed by the King John. He was forcibly brought to that particular place and asked him to append his signature, which is known as an assent. That's what, under pressure from his rebellious barons, which deals with protection of a church right, illegal imprisonment by the sheriffs, whether you make taxes, make the payment to the taxes in the form of a tax, it doesn't matter. Sheriff used to imprison them by misusing their discretionary powers. Look at the things. 1215, as the case may be, access to swift justice, limitation on the feudal payments. That means sheriffs, that means policemen were given a blank check to maintain the law and order in the barons. They could arrest any individual without any warrant. But this Magna Carta imposes restrictions against such sheriff or a policeman or the officers who have been so authorized to maintain the law and order against their rights of the church, illegal imprisonment, access to swift justice, as the case may be. It is still available, but Magna Carta could not sustain for more than 50 years. That's a different matter. But we still make a reference to it. We still make a reference to it. It is a written document, first ever written document, where king was given his assent for it. And it is available for us. And it is available for us, as the case may be. And we usually make a reference to it. It's a big bonanza for all the history students and also law students to study the Magna Carta, a great charter, which is also known as So Magna Carta of India. Now that means to say that following the 1857 rebellion, what we call it as a first war of independence, the East India Company rule of India came to an end. Queen Victoria, by proclamation of a 1st November 1958, declared that thereafter India would governed by and in the name of the British monarch through a Secretary of State. This usually call it as a modern Magna Carta. Until that, East India Company was actually ruling it. You can just imagine that. Just imagine that. A company which came to India for the purpose of a trade and a commerce, they start actually ruling and ruining the entire shape of the country. Nevertheless, on 1st November 1858, that was a day where Queen Victoria, Her Excellency, has taken over the East India Company and declared that under the Secretary of State, the entire India would be under the control of British monarch. And of course, as the case may be, we may not accept it. But unity was not there. Solidarity was not there. There were more than 600 kingdoms were there, claiming their separate sovereignty, as the case may be. Many foiled attempts were made, like Kittur Rani Channamma, Tipu Sultan, and various other people, because they were all small kingdom. They were all very small kingdom. They cannot actually, they were unable to fight against the big military power, gained military power enjoyed by the British government, as the case may be. It says that, but however, I mean to say that, I just wanted to make it very clear that, in my opinion, and according to some historian, as the case may be, it is the credit should goes to India. The credit should goes to British monarch to come out with a proper map of India. Proper map of India. That means to say that the extent of the territory of India that could be enjoyed by us was properly, clearly stated by the British monarch, as the case may be. Now you said that Myanmar was also, Burma was also part and parcel of it. Now, for example, Pakistan was also part and parcel of it, and some part of Afghanistan was also part and parcel of it. And as the case may be, now it is entirely different. As the case may be, right. So I just wanted to make it very clear. No, after that, when the British monarch came to their control, many enactments